Hello, everybody, and welcome. I am Administrative Law Judge Jeffrey Lee of the California Public Utilities Commission. Our program today is presented by the California Asian Pacific American Judges Association, Administrative Law Judges Committee, and the Asian American Bar Association of the Greater Bay Area. For further information about CAPAJA, you can check www.capaja.org, and about ABA, www.aaba-bay.com. So tonight our presentation and panel discussion is, what does fairness look like? Due process in and out of the hearing. We have 4 outstanding and experienced and very candid administrative law judges on our panel this evening. So I want to make the disclaimer that all views presented tonight are those of the panelists in their personal capacities, not necessarily those of their organizations, CAPAJA, or of ABA. Now I'd like to introduce our panel moderator, Judge Dorothy Chow Proudfoot. She is the administrative law judge with the San Francisco Rent Board. She is also a CAPAJA board member and co-chair of the Law School Outreach Committee, also the treasurer of the ABA Law Foundation, and past president and current board member of the Earl Warren American Inn of Court. So with that, let me turn it over to Judge Proudfoot.
Good evening, everyone. I just wanted to let everyone know I'm pulling double duty for this program as both the moderator and a panelist, but I will let you in on a secret. We have 49 years of judicial experience, so you don't need to hear from me at all. Our panelists are phenomenal and their wisdom runs deep. Just a couple of housekeeping issues. Please make sure you remember to sign up if you want MCLE credit. There is a link in the comment section, and we will also be requesting that you fill out an evaluation of our program afterwards. And if you feel like giving us all perfect scores, we would be very pleased by that. You can ask questions by typing them into I believe there's a YouTube chat, and we'll do our best to answer as many as we can at the end of our program. We'll leave some time for questions then. In the interest of time, I'm going to give you some ridiculously brief introductions for each of our esteemed panelists, but I would invite you to review their bios. The bios should have been in the written materials, but if they are not, we'll get a link out to everyone. So first, let me start with Kimberly Kim. Judge Kim became an administrative law judge with the California Public Utilities Commission in 2008 and retired as its assistant chief administrative law judge very recently. She has trained and supervised administrative law judges statewide. Some of her notable achievements include establishing and leading all of the remote hearing protocols during the pandemic and supervising the alternative dispute resolution programs at the commission. She is active in pipeline and mentoring programs and happens to be a past co-chair of the Administrative Law Judges Committee of CAPAJA, and also serves on the ABA's Judicial Division's Technology Committee, as well as the Executive Committee of the ABA's National Conference of Administrative Law Judiciary, also called NCALJ. One fun fact about Judge Kim is that just a few weeks ago, she summited Africa's roof, Mount Kilimanjaro. Next, we have Catherine R. Liu. She was appointed as an administrative law judge for the Social Security Administration in 2012. From 2014 until her retirement earlier this year, she led her office as the Hearing Office Chief Administrative Law Judge for the Social Security Administration's San Francisco Hearing Office. In my Google stalking of Judge Liu, I found out that we did have a tenuous connection 17 years ago, if only on paper. As it happened, we were both appointed Special Assistant United States Attorneys for the Northern District of California in our respective areas at the time. And that was something that I had not known prior to meeting Judge Liu. Judge Liu is an adrenaline-seeking traveler who has skydived over the shores in Oahu, ballooned in Cappadocia, zip-lined through the Australian rainforest, and driven ATVs across Iceland's rugged landscapes. So please welcome Judge Liu. And finally, we have Kristen Rosie. Judge Rosie has been on the bench for 18 years, most recently as the Chief Administrative Law Judge for the California Department of Insurance. She also serves as a mental health hearing officer for the Alameda County Superior Court and a court-appointed mediator and early neutral evaluator for the U.S. District Court for the Northern District of California. We're very lucky to have her as a co-chair of the Administrative Law Judges Committee of COPAJA because she is a nationally renowned expert for her work on access to justice. And frankly, she's impossibly busy. She chairs the ABA's Sexual Orientation and Gender Identity Committee, the ABA Judicial Division's Program and Education Committee, the Program Development and Impact Committee of the California State Bar's Legal Services Trust Fund Commission. She was a previous chair of the Council on Access and Fairness and is the immediate past president of the International Association of LGBTQ Judges. And she was actually named one of the 60 most courageous judges in the United States. One interesting thing about Judge Rosie that I'm going to be asking her about later is that she actually managed to sneak onto another committee that I did not know about, the Diversity Committee of the National Council of Juvenile and Family Court Judges. So welcome to our panelists. All right, so let's jump right into this. I'm going to ask each of you, what was your journey to becoming a judge? Let's start with Judge Kim.
Well, I don't think it was really a journey to become a judge. It was something that I stumbled onto. I wanted to be a litigator. I litigated for a little under 20 years, and I met a chief ALJ at the California Public Utilities Commission at a networking event. That's how it all started. And so it's one of those things. It was something that I wasn't interested in, but having litigated, I was persuaded that it might be okay and interesting to maybe go on the other side of the dais and become a jurist and participate in the legal process, not so much as an advocate, but as a neutral juror. So that's how I became a judge.
What about you, Judge Liu?
So like Judge Kim, I didn't plan on being a judge. I was really interested in public interest work. So I had an emphasis in public interest law when I was in law school and decided to go into work with the federal government right out of law school. And I was really happy with that. I did work in immigration and I also did work with Social Security. And like Judge Kim also, I met actually former colleagues who left Social Security and became ALJs. And they encouraged me and said, this is going to be the best job you get. So you should really look into it. And that's how I became interested in becoming an ALJ.
And what about you, Judge Rosie? What was your journey to becoming a judge?
Well, you know, unlike Kim, I never wanted to be a litigator. And I think I knew, like Kathy, I was interested in doing public interest law. I went straight into an administrative agency out of law school. I think I always knew that was going to be my path. And most of the work that I did as an attorney was appellate work. So a lot of decision writing, a lot of brief writing. And I was lucky enough to be in an agency that had administrative law judges. And so I got to see what that looked like from the office down the hall. You know, I got to participate when I became a senior attorney. I actually got to start conducting some of those administrative hearings. So I had the benefit of really seeing what that looked like. And then, like everyone else, realizing, you know, this is a possibility for my career that I never contemplated when I was in law school.
Yeah, no, it's such a contrast from my own experience because I was a deputy district attorney for most of my career. I worked up in Marin for 16 years, and I thought court was the be-all, end-all. I thought I was going to be a trial attorney forever. And when I started getting interested in the bench, I learned about the judicial appointment process for a gubernatorial appointment to Superior Court, which is a very long and involved process. But along the way, I had a mentor, a sponsor actually, who knew I was interested in becoming a judge. And opened my eyes to this whole additional world where you really could make a difference. And even though I had no subject matter expertise at my particular agency, my agency actually trains you on the job and will teach you how to do it. The key, though, is to really have the underpinnings of the skills that you need. And the concept of, you know, fairness and due process, as we're discussing today, really plays into the transferability of those sorts of skills. So let me ask then, I'm going to go back around. Can you just share maybe one aspect of how any of your prior jobs prepared you to become a great ALJ? Let's go with Judge Rosie.
I think I may have just sort of tipped my hand on that in my last answer. But I think my prior job, there was so much appellate advocacy, is so much brief writing. And as ALJs, unlike you know, most other trial level judges, ALJs write. They write quite a bit. And so having a strong writing foundation was something that I think helped tip the scale when I was applying for ALJ jobs. I think it also helped that I had done some appellate advocacy and oral argument work. But I think for me, it was the writing skills that was the skills that I brought. I think I wished I had had the trial experience that I know lots of the rest of you had. I didn't have that, but I think that the writing skills was so critical because ALJs write to such a broad audience.
Yeah. And what about you, Judge Liu? Can you draw a picture, draw a line between a prior job and your work as an ALJ?
So I would agree. The writing was a big part of it, but also the oral advocacy, being able to think on your feet when you're in court, both at the district court level and at the appellate court, and also even at administrative hearings, you know, being ready to answer questions and being prepared to address issues that just pop up at any time. Because that also happens during the administrative hearings that we have. Issues that you may not have thought were relevant suddenly become relevant, and then you have to pivot and be able to adjust. So I think my work at the Office of the General Counsel when I was with Social Security, and that when I was there, I was a special assistant U.S. attorney. So I had practice in both the administrative level and at the district court and the Court of Appeals. So.
Mm-hmm. And what about you, Judge Kim?
With both Kristen and Kathy, just slightly different in addition to those things. For me, I think, you know, having gone into litigation and approaching litigation as very skill-based approach to justice, and learning from judges, different judges, really showing heart and how that plays into how justice can be reached in the courtrooms. I've had good judges, I've had horrible judges, scary judges, rude, you know, just heartless judges. And I think all of that really sort of taught me how I could be a judge that could create a courtroom that allows folks, as we're talking about today, to be afforded their due process in my courtroom. And so I don't know if it prepared me for greatness in courtroom, but it prepared me for the courtroom, what I wanted to be and what I didn't want to be as a judge if I were to be one.
Yeah, no, that's a really insightful observation. I think a lot of folks, they don't see necessarily the through line from being an attorney to being a judge, but to understand that you should be looking to the judges to see whether they're doing what you expect someone in a fair system to do. That's very important. So let me dig a little deeper into this. My next question is, what does due process mean to you? And let's go back to Judge Kim on this one. What does due process mean to you?
I mean, I think just drawing from the experience that I had at the California Public Utilities Commission, we have various types of proceedings. We have what's known as quasi-legislative proceedings, where it's almost rulemaking type. We have rate-setting proceedings. We have adjudicatory type of proceeding, where it's advocacy and litigation, adversarial type of proceedings. And in various types of proceedings, I think due process, litigants are different, issues are different. And I think due process that would be due in the different types of disputes differ. So I think the answer to that is a little bit convoluted to say it depends. It depends on what's at issue to define as a judge what one needs to do to create process that is due, that would afford a fair process, a meaningful process for the litigants in that type of proceeding.
Okay. That makes sense that, each situation demands its own policies and procedures and ways to accomplish it. Let me turn to Judge Rosie. What does due process mean to you?
Yeah, so I think, what Kim said and what you reiterated is true, that it's different in every situation. And one of the things that I think about, and this is probably important for folks to know, and I know we all know this as ALJs, but most people, when they experience court in their lifetime, are going to experience an administrative law proceeding. I think the number is pretty staggering. It's something like 75, 80% of people will only ever see an ALJ. Due process to them is whatever process we're providing them, right? And so it has to be an impartial proceeding. It has to be independent judiciary. It's tricky for ALJs because many of us are embedded within the agencies that whose cases were adjudicated. So, for example, at the Department of Insurance, the Department of Insurance is a litigant in many of the cases that are in front of the ALJs. And to a lay person who sees a judge employed by the Department of Insurance and attorneys employed by the Department of Insurance, that looks like a stacked deck. And I think it's really important that that ALJs explain that our process is separate, and that the ALJs are independent. We're issuing independent decisions. We're going to follow these rules. We're going to treat everyone like a separate party, and that makes due process in an administrative proceeding a little trickier.
Yeah. So it really is about making sure that everyone who's involved understands the roles that are occupied by the various parties, and to understand that there is a higher obligation simply than to who's employing you, a higher obligation to the concept of fairness and justice.
Right.
Yeah. And so let me turn then to Judge Liu. What does due process mean to you? I know that your proceedings are sometimes a little different from state proceedings, not only in the subject matter, but just procedurally. Federal ALJs have slightly different setups.
Yes. So in Social Security proceedings, for example, it's very different because there's not a representative from Social Security and the claimant. The claimant is usually the only one and in the hearing with a representative. And for due process in Social Security hearings, I think it's really important that the claimant feels that they are being given the opportunity to be heard, because in the administrative process, it's very rushed. So this is their one chance where they actually get to explain their story about why they're seeking benefits. And when I had hearings, I would make it a point to explain how the process was proceeding, because as has been mentioned, many of these people have never been in a in any type of legal proceeding before. This is the only time. And by explaining it, it puts them at ease so that they feel comfortable to explain what they're looking for or why they're before you. I think it's also important that due process allows for all the issues to be heard. Oftentimes, claimants in Social Security hearings they have one point. They just want to say, I'm disabled and I want to get benefits. But there's many things that we have to uncover to make sure they meet the requirements for disability. And when I'm having a hearing, I just want to go through all of those to make sure that every issue that can be covered is covered, which is kind of challenging given that we have a limited amount of time to have these hearings. But I think it's just making sure that the claimants feel that they're being heard and that the proceeding is viewed as being equitable, that they're getting a fair shot.
Yeah, and we know that not everyone can win every case because there's multiple sides. Sometimes it's 2, sometimes it's 3 or 4 or 25. So the real key to making sure that the system works is that everyone feels like they got an adequate opportunity to be heard. When we look to California law, to the Administrative Procedures Act, there are requirements, and these will be in the written materials. There are, these guidelines as to how to really ensure a fair process. We also have the Model Code of Judicial Conduct 2.6 subsection A, which actually states a judge shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. So this right to be heard according to law is in both the state and in the federal governing laws. So what does that mean to you, the right to be heard? Let me go to Judge Rosie.
Yeah, I mean, I think that you make a good point. It's in both the the APA and the federal rules, and there's a corollary to that in the Judicial Code of Ethics, which California state ALJs are also bound by. So the right to be heard, I think, looks different, right? It doesn't mean that you have the right to talk for hours and hours and hours. It doesn't mean that you have the right to bring in irrelevant information, right? It's still a court proceeding, but what it means in an administrative law setting is that you're going to have an opportunity, oftentimes, if you're a pro se litigant, to testify on the stand, and frequently, at least at the Department of Insurance, the judge is the one asking the questions. I oftentimes let pro se litigants, do a sort of a little monologue, tell me what you think I need to hear. But because ALJs are so focused on creating a full, complete administrative record, we're asking questions. And so oftentimes your right to be heard is supplemented a little bit with the ALJ's right to get information. So it's having that opportunity and feeling like the person on the other end, the judge in this case, is listening. And I think that's, again, one of those unique features about an ALJ, because we ask questions, because we're subject matter experts. We know your case inside and out, oftentimes better than you do. And we can ask those questions that really make people feel like we're following along. I know, if you've been a litigator before, and especially if it's a jury trial, you see the judge like this. And you're fielding objections or those kinds of things. But ALJs are really listening. They're really following along. They're asking questions during the proceeding. And I think that actually makes people feel like these proceedings are giving them a fair shake.
Thanks.
Can I jump in and just mention that along the lines of what Kristen's saying about developing the record, oftentimes unrepresented claimants don't know where to go. So we help them, like, which doctors did you see? What medical facilities did you get treated at? And sometimes we even help them get those records because they can't get them on their own, or they don't know how to get them on their own. And I think that's another way of showing that we're making sure that they're getting adequate due process during the proceedings.
That's a good point there.
And
Um,
yeah, on that thread, the right, Kristen's right. The right to be heard has the other sort of corollary that is aligned with our ALJ's duty. When we make our decisions should be record-based, right? And it needs to reflect what we heard. And part of that, as we're writing our decision, sometimes is to thread those facts and presentations of what they presented. And especially, and I think it's particularly the case when we are deciding against, say, party to actually indicate and reason out, I've heard this piece of testimony and this piece of evidence, and for these reasons, they were not persuasive. And then actually explain that out, because then they are heard. The decision reflects that they've been heard, and then the decision reflects record-based their treatment. That is part of the due process. So I think, right to be heard is only part of the whole due process, which is to be actually heard and be folded into the decision-making process.
Right. So, I want to pivot just a little bit here, because I think we've jumped into administrative procedures without talking a lot about what it is that we do. So for example, I am an administrative law judge at the rent board. And so I'm always hearing cases between landlord parties and tenant parties under the rent ordinance. And so I always have evidentiary hearings. Those are the things that I cover. And so I need to do things like evaluate credibility. I need to give people an opportunity to cross-examine the other side, to really flesh out the facts and to find out if there's something else going on that maybe one party isn't mentioning, but that the other party can raise. Judge Liu, let me ask you, can you tell us a little bit about, you already mentioned that Social Security hearings, oftentimes the department will not be there, the agency will not be there, but it'll be a claimant and their representative trying to persuade you of what is it that they're trying to get, what kind of finding are they trying to get out of you?
They're usually trying to find, it's a disability case. They're usually trying to show that they're unable to work and that they should be found disabled under the Social Security Act. And there's different rules that we look at, age, the type of disability, those factors play into it. I think the difficulty is sometimes it's just so a narrow focus where they're just saying, I just can't work, and that they think that's enough, and there's no evidence to support it. So I will be having a hearing and I'm like, okay, so these are your impairments. Can you give me some information or details about, for example, it's a back impairment and you say you can't work and you can't lift things. Okay, what kind of treatment have you had? How has the medication affected you? Things like that. I will delve into those factors that could impact their ability to work. And sometimes I'll learn that it's not really the back impairment. There are other things that come up from it. For example, they could have a back impairment, but they also suffer from nerve damage, and they don't even talk about the nerve damage. And so then I start going down that route and finding out more about, okay, so the nerves are in your hands are affected now you can't finger, you can't do things like can't type, you couldn't do things like that. So it's interesting because sometimes you'll go down one path and end up taking three other, turns to find out whether the person meets the requirements for disability.
Okay. And is your decision sort of the first opportunity, or is it that a state agency or a federal agency has already made a determination that the claimant is appealing?
Usually the state agency has made two determinations. There's an initial determination and a reconsideration determination. The reconsideration determination can happen. Sometimes they skip that step, but there's some waivers on that. But generally speaking, there's two administrative considerations before it comes to my level. And then after my level, then it goes to the appeals council, which is the appellate administrative board. And then if they are dissatisfied with that decision, then they can go to district court and continue the process there.
Okay, thank you. Judge Kim, can you tell me, I think you may have among the the widest range of types of cases that you will see. Can you tell us a little bit about that?
Sure. So the most sort of akin to the type of proceeding that most administrative proceedings have, we have what's known as adjudicatory proceedings. Those are simply a complainant filing a complaint against a utility, let's say. So PG&E, for instance, Pacific Gas and Electric, billed me too much in the last 3 years, and they have claimed. And so it would be PG&E versus the complainant, or complainant versus PG&E. Those are called adjudicatory. We have, for those types of cases, we have regular jurisdiction complaint proceeding, which runs very similar to Superior Court proceedings. And we have rules for that. And we have small claims jurisdictional level, which are called expedited complaint proceedings. They go much faster and have much fewer rules. And so they run much as the same as the small claims proceedings. We have two others that are more common, and the fourth I won't even mention because it won't make sense in this context. So the two others are, one is rulemaking, and so we will adopt rules and regulations that will affect an entire utility industry, water industry, all the water suppliers, or energy industry or transportation industry. When we take that type of proceeding, that's called a quasi-legislative proceeding, and we could have up to 200 parties in such a proceeding, and that could run for several years. And then we have right in the middle rate setting proceedings, which are setting of the rates. They happen cyclically every few years for every one of the utility, what rates that they can charge and for what reason, etc. And so, and going back to your question, those are the kind of proceedings we have. Was there another part that I missed?
No, we just needed some more background so that people can understand what are the considerations that the ALJ is managing while trying to hold these hearings. So let me turn to Judge Rosie. So what at the Department of Insurance, what types of hearings might happen there?
So the Department of Insurance ALJs have jurisdiction over the numbers, 45, 50 different types of hearings. But most often what we're hearing are rate setting hearings like Kim was talking about at the PUC. Department of Insurance rate setting is all over the place in the news these days. So rate setting hearings, and those are, very formal proceedings. My courtroom looks like actually looks much nicer, in my opinion, than most of the courtrooms you'll see in a superior court. It's a formal looking courtroom, and those are formal proceedings. I think this happens in Kim's cases as well. We have consumer interveners in our cases. So it might be the utility, it might be the utility, the department, and one or two consumer groups. So you could be managing a very formal proceeding with cross-examination and, motions to strike, motions to compel discovery with, 4 or 5 different parties in front of you. That's not unusual. Or it could be something as simple as a workers' comp classification issue where an employer thinks that their workers' comp carrier is charging them too much and isn't following the rules. or it could be non-compliance. An insurance company isn't following its own policies in how it pays claims. It could be a variety of things, but they tend to be, fairly formal proceedings. It always held in a formal courtroom, unless we're doing it virtually.
And lots of lawyers involved.
Lots of lawyers, but lots of pro se litigants as well. It's a mix. Obviously, the more formal the proceeding, the less pro se and the more attorneys from all over the place.
Let me pivot then a little bit. Now we have a little understanding of what types of hearings that you might preside over. What is one thing you wish attorneys who appear before you should know? Who wants to answer that one first?
I'll go first. Oh, no, Kim raised her hand first.
Okay, go ahead, Kim. Judge Kim.
Defer to you. But yes, I have a big pet peeve. And so I'm so glad you asked this question. Mission has a very, very particular set of rules. We're outside the APA, and most of the administrative litigators come in thinking that APA applies. They're not familiar with another set of rules that we have, and they try to argue and apply those rules when we have a specific set of rules that we blast to them every time they appear near us. And so my pet peeve is, please read the rules.
Yes, those are some wise words for any jurisdiction in any court. What about you, Judge Liu? What are things you wish attorneys
I totally agree about the rules. One of the basic rules we have is like a 5-day rule, like get all your evidence in 5 days before a hearing. And then I'll get, 1,000 pages dumped on me the day of the hearing. And I'm like, when would I have read that? Like, I can't review this and be fair to the claimant and ask relevant questions with having this. But I think one of my things is I would like attorneys to be prepared with the case. Being familiar with the facts of their case makes the hearing go so much smoother and so much faster. When they're not familiar, it shows. It really does. So.
And a lot of times administrative cases tend to be high volume too. And so have you seen a disturbing tendency for people to think, oh, well, no one's going to expect me to be up on my case, and we all just sort of muddle through? Have you seen that type of attitude?
Yeah, the agency has a high expectation for judges. The last I heard, it was like 500 dispositions a year, which is crazy. But and that's my personal opinion. That's nobody else's. That's mine. But that's a lot. But in order to do that, I have to be efficient. And so, if I'm spending the time reviewing the case so that I can have a hearing within an hour, you help me along, have the issues, know what issues I'm going to be looking at or focusing on, and let's go with that. But, when sometimes the representatives are not familiar, or they picked up the case at the last minute, it's unfortunate, because the one that suffers the most isn't me, it's the claimant.
Mm-hmm. True. What about you, Judge Rosie? What are some things that you wish the attorneys who appeared before the Department of Insurance should know?
I'll say in front of the Department of Insurance, but also in front of any administrative agency, and I have a cautionary tale that goes with this. Administrative proceedings are real proceedings, and the decisions that the ALJs issue are real decisions, and they have collateral estoppel of impact on things that happen next. So take the proceedings seriously. You alluded to, lots of lawyers. There's lots of lawyers that come into the Department of Insurance courtroom and maybe don't take the proceeding as seriously as they ought to. And I've had, folks get on the stand and refuse to answer questions. I've had folks refuse to respond to the subpoenas that we've issued. And then when they get a decision that is not favorable, they go to the appellate court and they say, well, I didn't get to testify about this, that, and the other fact. And more than once, the court has come back and said, well, the ALJ, you know, subpoenaed you, you refused to comply, or you were on the stand, you refused to answer the questions, you're out of luck now. You don't get a second bite at the evidentiary apple because you didn't present it at the administrative hearing. And I think that folks, there are some attorneys out there who do not understand this is your chance to put in evidence. To Kim's point earlier, we're making a record. And that is the evidentiary record. That's the only evidentiary record the appellate court's going to look at. And so if you want somebody to consider it, you better give it to the ALJ. And I've seen lots of folks try to play that sort of game of, I'm not going to turn that over, I'm going to turn this over, or I'm going to give you half of the information. Weirdly, Kathy just changed direction on my screen. And maybe
I don't know what happened.
Okay. I thought it was me. Okay.
No, we're all seeing
okay,
it.
we'll try that.
Okay.
I was quiet. I thought it was just me.
That was weird. I didn't do anything.
Yeah, so that, I mean, that's my sort of pet peeve, but also cautionary tale, is these are real proceedings, real evidentiary proceedings, and this is your chance. And so to Kathy's point, be prepared. And to Kim's point, we're making a record, and this is the record. So treat it with the care that it deserves.
Can I jump in here for 1 second? There's a question that was raised by one of the attendees about how to get the state appellate courts to understand some of these technical issues when Superior Court missed the ball, right? And you know, some of the concepts that we have to deal with, Kathy in Social Security realm, you, Kristen, in insurance realm, us in utilities realm, they're very, very arcane concepts and very, you know, there are nuanced issues with long history that requires extensive discussions. So I just wanted to say, to underscore Kristen's point on the earlier question, which was really take your case before the administrative law judge seriously in building your case when you first appear. Because that's going to be the foundation based on which, if you had to challenge and you're in that awful situation trying to explain to the Superior Court and then to the Court of Appeals how this is all going to unfold, but you have to present everything the first time so you don't have a res judicata argument, collateral estoppel argument, administrative exhaustion argument. That's all going to come at you at the appellate level. But really, you know, how do you convince the appellate court? Appellate brief. You know, that's really where, you know, if you've got all of the evidence in there, stacked in there, you got the foundation, you weave it better the second time. You try to convince a Superior Court judge and you just couldn't, you didn't get a judge that got it. But Court of Appeals, you get another shot if you can get them to understand it, as long as you put everything in the record based on which you can make those arguments. So I just wanted to actually kind of point that out.
Yeah. Let me just add a little something to that. And it goes along the theme of help us help you. Because if you present the full argument to the administrative law judge and put forth your best advocacy, succinct advocacy efforts, it's much more likely that that judge is going to incorporate your language into the statement of decision. It's much more likely if you have a very clear statement, either in written filings or in your oral advocacy, that frames the issues in such a way that they're easily identified and understood, and it's very clear what the question presented is. That if you frame the issue in that way below, then the document that the next level is looking at is going to be the judge's decision. And the judge's decision, if you've done a good job of showing the judge what the issue is, even if the judge rules against you, at least you've got a clear statement of what the issue is. And then you can go to your appellate court and explain the judge misapplied this particular rule because, you know, here's the question. And so I think that that is definitely a way. Think about the idea that, you know, an appellate argument doesn't live in isolation. It doesn't exist by itself. It really is a factor of what you've laid in the record and what you've been able to get help from the judge because the judge agrees that your question presented is the very question, that's actually going to help the appellate court a lot, because then they can look at the reasoning that the judge below had, and as opposed to having to come up with it all from scratch. Okay, so that is potentially something that you can think about as you're dealing with a novel issue that you suspect might need some appellate treatment. Let me turn a little bit now to, an idea. I'm looking at the time here. Let me ask our panel here. Do you think that people appearing, notwithstanding the fact that you still have to treat an administrative hearing as seriously as you do a superior court hearing, is it a good training ground for newer attorneys when they're just, finding their legs and just learning how to really be a good advocate in a proceeding? Would you say that you think it's good, bad, indifferent? What do you think? Judge Kim?
I'd say yes. I mean, having not gone into administrative law before, I would say I would have done so much better. The face plants that I did, making dumb mistakes that I made, and the judges in some of the courts that I were in, not very kind. They didn't look the other way. And I will say most of the administrative law judges I know, and I've been an administrative law judge or an assistant chief ALJ for 18 years total, and almost all of my peers during that time, including you all, I know you guys wouldn't treat litigators the way I was treated when I flopped. And so it was rough. The first few years trying to get my leg under me was pretty rough. And I say there's a lot more leniency and humaneness in the ALJ ranks that I've seen, where you can learn the process of litigating advocacy process in a more civilized way, I think.
I think that
Sure.
I agree entirely with Kim. I mean, it's a much kinder environment to get your feet wet in. If you make an argument, and I just know, I'm just going to give an experience from my first oral argument before the Ninth Circuit. I was reamed. Like, I was shaking in my boots and I was reamed. And one judge was just particularly harsh. And I remember him to this day, but I also remember one of the panelists who was throwing me softballs so that I could get my feet back from I could stand again, So I think for an administrative hearing, and it's much kinder and it's much easier to start getting comfortable. And the more cases you do, you get better at it and you're more familiar. But I think it's a great training ground.
And have you had instances where you very much wished that the civility oath that's going into effect next year, April 1st, to conduct themselves with dignity, courtesy, and integrity, have you had occasions where that really felt very sorely needed in the types of proceedings that you've done? Judge Rosie?
Yeah, I mean, I think that I don't want to say it's generational either, but I think because of the informality of the way that most people see the informality of administrative proceedings, that there is this idea that also, in addition to the informality of the proceedings, is the informality in the way that I address the court, or I address the other attorneys, or I address the witnesses. I don't see that as much with attorneys who have practiced for a long time, but I do see that more in younger attorneys. And I think that it's also very different. I mean, we have to think about the fact that there's an entire new crop of attorneys who have only ever appeared in court virtually. And to Kathy's point about doing an oral argument, if you've never stood in front of a panel, or one judge or three judges or five or however many, right? If you've never stood there in that room and like felt your legs shaking and held on to that, dais for dear life, it's very different than sitting in pajama bottoms in your kitchen, making an oral, doing oral argument. And I think there's I think we have to be cognizant that there's an entire group of young lawyers who have not had to stand in a courtroom and do the things that you do when you're in a courtroom, right? Nobody's, people stand when I walk in. I don't like that part, but the standing, the sitting, the approaching, the handing of things, none of that stuff happens, in this virtual world. And so I think that, now going back, and most people are going back in person, and getting that sort of your feet wet in an administrative proceeding, I think is going to be more important for this next generation than perhaps it was for any of us.
So let me pivot then to talk. We've been talking a lot about things, and I don't want us to end on a downer. So I want to try to have one more question, and then see if I can handle another question that was in the chat here. So those of you who know me know that I will ask this question at all times with every ALJ. Why is being an ALJ the best job in government service? Kim?
Well, I love my job. Why is it the best job? I have not had Kristen's job. I have not had Kathy's job. I have not had your job, Dorothy. But at California Public Utilities Commission, we make decisions that are really, really progressive. It's interesting. Every case is interesting. We touch lives with all of the cases that we have. Every day we make a difference, and I loved doing my job. And I felt like I was doing public service every day of my 18 years there at the ALJ division. And so I love my job. There are 1,000 reasons. I don't think we have time to list them all, but it's a great public service role.
Judge Rosie?
I mean, I think part of it is what people say about state employment in general, right? There's a work-life balance to state employment that is different than in the private sector. So I think that appeals to folks. I will also say, and all of you know this, but maybe the folks watching don't. There is a diversity amongst the ALJ sector that is not matched in either the federal or state court. It is simply a more diverse judiciary, and which I think benefits litigants as a whole, and I think makes the ALJ core stronger and better. And so I think those are two really two pros for the job. And like Kim, been an ALJ for 18 years. So it must not be a terrible job, or we wouldn't still, have, what did you say was 47, 49 years of collective experience? Like, it's a lot of ALJ experience. And that doesn't count Dorothy's. So,
yes, with me, it's 57, I think. Right. So
yeah.
we are more than happy.
If anybody watching needs a plug, it's that, 4 people have done the job for 57 years. Like, it can't be terrible.
Yeah. Judge Liu, what are your thoughts? I love to get your perspective because you're in the federal system, which is different from, it's something I'm not as familiar with.
I agree with everything that Kim and Kristen have already said. I think one of the biggest privileges I had was to be an ALJ and being able to, in the particular type of cases I had, I can see a difference that I made immediately, because somebody getting benefits who really needed it, you get that information, you get that decision out sometimes within a day. That's so fast, and it's going to change their lives. And that's it's a great feeling that you're able to make a difference in people's lives. The other thing I would say is with the colleagues I had in Social Security, especially, the federal employees, there's a dedication there. I'm sure that's there at the state level and at the rent board. I'm sure it's there at every level, but especially for me, seeing it in Social Security, the people that work there really want to be there. They really want to help. They really want to make a difference. And it's an honor to work with people that care like that. And they put in the time, so they deal with crazy roller coaster rides with no budget or a shutdown and things like that, but they're still plugging away. And, I give them all my credit.
That's wonderful. So I do want to try to get to one of these questions that I saw here. And that is, how do you guarantee language access and certified interpreters in your proceedings? Let me turn to Judge Rosie.
So I won't speak for the PUC, although this may apply to the PUC as well. But the government code here in California actually guarantees language access and certified interpreters. And there are a number of agencies that are, they're actually enumerated in the government code that have to provide that certified interpreter, the language access, and Department of Insurance is one of them. So, as chief, that is one of my jobs is to have there's a website that the state of California operates that has a list of language interpreters, and that is something the agency is obligated to cover for any proceeding. And we have done it at the CDI over the years that I've been there. When people ask, it is a guaranteed right in many agencies. So I think PUC is probably the same, but I'm not sure. Kim might know.
Yeah, we do. And the way we do it is like in any other superior courts, where before their first appearance, parties need to indicate whether they need such service, and then we will provide that service. If they don't, and they appear to need such service, and we can't proceed, we will then continue the proceeding until we can find that service and reset the matter. And so that's how it's handled at the California Public Utilities Commission.
Yeah,
It's similarly handled in Social Security cases. Generally speaking, Social Security cases now, the interpreters are not in person, so oftentimes they're by telephone. But we used to have interpreters come in person to the hearings.
Yeah, and I can offer a slightly different experience with my local agency at the San Francisco Rent Board. We will provide an interpreter if you have a financial hardship and you can't hire one yourself. You just fill out like a one-page form and we do a quick verification, and then we actually pay for interpreters in many different languages. We have a contracted service to get good interpreters. And as far as assuring language access, I can tell you I've had a situation where I had an interpreter who appeared to be insufficient and kept having to pause and look up words and saying that they didn't understand something. And I stopped and I said, we can't continue like this because we're not giving meaningful access. And so that has happened before. It's happened before where I reported after a hearing which seemed problematic. I reported to my direct supervisor that we needed to have a conversation with the company that we were contracting with, that we could not have a particular interpreter again, that it was not appropriate. It was not assuring anybody their due process rights. So, and those are really obligations that the ALJ has in controlling the proceedings, because there's nobody else who's going to do it. I mean, I had a case just today where a party said the interpreter interpreted that wrong because he wasn't the person who needed the interpretation, but he understood enough that he said, oh, that was a mistake. That wasn't interpreted correctly. And that's great when someone can bring that to the fore and then you dial down and try to make sure that it was an accurate interpretation. But sometimes you don't have that. So the administrative law judge does need to pay attention and make sure that what is happening, without just asking yes or no questions. You ask for elaborative questions sometimes just to prove that somebody is actually communicating what they want to let you know. So there's all kinds of issues like that, some of them people know from before if they're bilingual, trilingual, but if you are not, you will learn that on the job, that you will be able to see that. And it's part of your obligation. It is 6:31, and there was one more question. And I'm just going to ask any of my panelists are my panelists okay to stay another 3 minutes?
Sure.
All right, great. So then another question we got in the chat. Do you have any thoughts on how due process is affected if it seems as though a party has already been deemed guilty by an administrative agency despite the findings of an ALJ? And I'm going to ask actually for clarification on this, because there's two different levels we can talk about. If there's an ALJ finding and then there's an adjudication after that, or if the ALJ is reviewing the findings of an agency, right? So let me turn to Judge Kim. Can you talk a little bit about, even though I know their guilt is not the issue at a CPUC hearing, but certainly if there's some issue of fault, if that seems to already be infecting the process.
Well, yeah, I was a little confused by the question, but I think what I'm hearing is from that question is that ALJ finds one way, let's say adverse to complainant, and then somehow decision is adopted that is contrary to the ALJ's finding. Is that what you think the question is?
Oh, I read it the other way. That's interesting.
Okay, well, why don't you answer the question that way first, and then we'll answer it again second, the other way.
Yeah. So that's what I was going to answer, and then maybe we would answer if the question was the other. And so that does happen, and I think this goes to ALJ's duties. We have a duty to create a record and make a decision that is based on the record, and it's our independent decisions. So our independent decisions are rendered and our findings based on which our decisions are issued based on the record. If, let's say, our commission or a board or an agency decision maker, second level decision maker, overturns that and flips that decision around, they also have to find their reasoning and their finding based on the record, and whether that's happened or not, that would be an appellate issue. And those things do get challenged if those things get flipped from ALJ level to the next level, where the findings have gone from one way to another. And it's really based on what's in the record. Does the record actually support that second finding that went the other way? And so that happens a lot, in my experience. And it's all about making a good record from advocacy perspective to make sure that you preserve your client's rights, whichever way you're landing as a litigant.
And I can also add that this is a very important reason why attorneys need to get engaged and involved in promoting judicial independence, because this is also a judicial independence question. If the judge finds, based on a rational consideration of all relevant factors to make the decision, then that is what's supposed to drive what the outcome is, right? It can't be if the agency wants to make a different decision for other reasons, independent or separate from what the actual facts show. And so the more that we can promote the independence of a judicial officer who is tasked with making a fair and impartial decision and setting forth the reasons and really showing their work, we've got the receipts, this is what has happened in this case, then without that, you can't get justice. With that, you have a much better shot of prevailing in front of a different tribunal or a higher tribunal to try to show that some decision making was arbitrary or not based upon the facts. So that's my pitch for why judicial independence at all levels is really the hallmark of making sure that people are treated fairly in our governmental systems. Any closing remarks, because it's already 6:35? All right. With that, then, I'm glad that we were able to answer. Looks like all of the questions there. I hope that our audience has had an enjoyable evening with us. We certainly appreciate the opportunity to talk about how much we enjoy our jobs and some of the challenges that we sometimes face. So I would encourage you to get involved with ABA if you're not already involved with ABA, and if it's not ABA, find another organization to get involved with, because we all learn from each other. The more we can have these sort of panel discussions about issues that are important to all of us here in the legal profession. So with that, I'll say good night.
Good night, everybody.
Good night. Thank you.
Good night. Bye, everyone. Thank you.